Supreme Court to hear a challenge to ban transgender healthcare for the minors. And here's what the story tells us over from SCOTUS blog, which is more or less a neutral purveyor of the facts of SCOTUS cases. Says the Supreme Court on Wednesday will hear a challenge to a Tennessee law that bans the use of treatment, so-called, for transgender teens. And the dispute could be one of the most significant decisions of the term. Similar laws in 23 other states, the court's ruling going to have broader implications for the protections available to that group. Enacted in 2023, there's a Tennessee law called SB 1, declares the state has a compelling interest in encouraging minors to appreciate their sex, particularly as they undergo puberty, prohibiting certain things from happening. The law, however, allows the use of the same treatments for other purposes. For example, if you're experiencing early puberty, you can use those drugs. 3 transgender teens and their parents filed a lawsuit emphasizing that the drugs now barred by SB 1 have been a lifeline for them and they need it. Federal District Court in Nashville determined that SB 1 violates the Equal Protection Clause. You can't treat different people differently, dissimilarly. And a divided court of appeals reversed, upheld the ban, and now they're at the Supreme Court. The Biden administration and the family say that the ban on these blockers and therapies is a type of discrimination that requires heightened scrutiny. They say it distinguishes between medical care based on the sex that's assigned at birth. So lawsuit made its way up to the Supreme Court, and it is going to be a spicy one. So a decision in this case is expected by the summer of 2025. They are in oral arguments as we speak. And so let's listen in to a little bit of what that sounds like here from the Supreme Court live.
Of heightened scrutiny, whether they be intermediate or strict, require courts to make the judgment, the means ends calculation in this kind of medical context. Because I agree with you, I can see your point, like as a matter of logic, we should shift this to that stage, assuming that the suspect class is triggered and we say this is sex classification. But is there any other situation in which courts get into that in the tiers of scrutiny?
So I would point, Your Honor, to recent cases involving the COVID-19 pandemic, in which many cases came up before this court in which the states were regulating, undeniably in areas of public health and evolving science. And the court repeatedly made that, yes, of course, the states have latitude through their police power to regulate. But when they do so in ways that classifies based on suspect lines or infringes constitutional rights, then heightened scrutiny remains the standard that the courts apply to ensure that the state is advancing an important governmental interest.
Yeah, I guess I'm thinking of some, can I just, this
Sure.
last follow-up, but even in those COVID-19 cases, courts weren't, and we certainly weren't, diving deep into the medical evidence and comparing Europe and America and looking at research. This would be, I think, of a different order. Do you agree?
I don't agree, Justice Barrett, in the sense that I do think it is precisely the role of the courts to assess the tailoring and look at the evidence, whether it's presented through expert testimony or not. It is not the role of the court necessarily to say definitively these risks outweigh these benefits or vice versa, but do what the district court did here, which is to look at the assertions of harm, make comparisons to how Tennessee treated all other medical care, and then see whether or not Tennessee had met its burden under heightened scrutiny. That type of tailoring inquiry, I believe, is precisely the role of the court.
Counsel, in the COVID, I have a colleague to my right, whom I think very highly of, who spoke about the need of the courts to look at that evidence to ensure that there wasn't suppression of religion, correct?
That's correct, Justice Sotomayor.
Now, with respect to Justice Barrett's question on COVID, in my mind, it's a little more similar to the bathroom situation, because there, COVID was a risk not just to the individual and the threat to their own life, but their contact with others could threaten others. So the compelling state interest was different than just a pure medical issue, correct?
That's correct. I totally agree. The state interest was different.
All right. With respect to treating that issue, you can hear from some of my colleagues that they're worried that, and there is a plethora of science in this area, both that developed in Europe, and the lower court hasn't really looked at it. No one has.
Science.
That courts are ill-suited to that. Why do you think they're not?
They are ill-suited.
What about the fundamental role of the court makes us suited to answer those questions?
Well, I think first, Justice Sotomayor, the role of the court is to ensure that when the government draws lines based on suspect classifications, that the states are tested to ensure that they're substantially advancing an important governmental interest. And when it concerns underlying questions of medicine or science, the judges and judges in the lower courts have every ability to assess the testimony before them, as the district court did here. This is not an area where I believe Tennessee is saying that medicine is altogether an area in which suspect classifications have no bearing on the judicial inquiry. It is precisely the role of the court to ensure that the government of Tennessee has substantially advanced an important governmental interest.
I have one small question to finish with. The regret issue that was raised to the Solicitor General. Respondents cite a figure of 85% of children expressing gender dysphoria regret later. You use a figure of 1% of minors who receive this treatment expressing regret.
Why are those numbers so far apart?
Can you tell me where those figures lie?
C-SPAN, what happened?
Expressing regret and the 85%?
Certainly, Justice Sotomayor. And so the first point I would say about the 85%, and we address this on page 22 of
85%
our reply
regret
brief,
the
that's
transition.
a misleading figure for two reasons. I think most critically, it
Why?
refers
It's like
to
99?
older studies of prepubertal children. And everyone here agrees that the medications that are banned by SB1 are only prescribed to individuals after the onset of puberty. And in JA 151 to 153, the evidence shows that once an adolescent reaches the onset of puberty, their likelihood to ultimately desist and identify with their birth sex is very low. And then as to the question of the 1%, the question of regret, which is a different question than what happens with prepubertal children, the record shows there that the rate of regret when people receive this medication after the onset of puberty is as low as 1%, and that's in JA 131 to 133. And I think what's important here, and the Solicitor General mentioned this, is that is exponentially lower than the rates of regret of treatments that are expressly permitted by SB1.
Thank you, counsel.
Could we explore what intermediate scrutiny might look like in operation in assessing laws like Tennessee's? So the Solicitor General on page 48 of her brief lists a lot of things that she says if Tennessee were really concerned about the health and welfare of these minors, it would have taken into account a variety of things. So one is waiting periods. Another is whether puberty blockers should be exempted. Another concerns things to make sure that the future of these minors is properly respected, even though they personally cannot make mature judgments about potentially irreversible procedures. So she mentions things like two-parent consent or counseling, readiness criteria, age recommendations, licensing, certification, or reporting requirements for physicians, and other guardrails which are not specified. So if intermediate scrutiny were the regime that would apply, would it not be the case that judges would have to decide whether a particular package containing this much of that and that much of the other thing is sufficient? Wouldn't this be endless litigation with the decision based on determinations by lay judges regarding complicated medical issues?
So if I could make 2 points in response, Justice Alito, and the first is going back to the Solicitor General's example of West Virginia, where West Virginia looked at the underlying science and instead of categorically banning this medical treatment, created pathways with guardrails for individuals to access medical care. There has been no litigation over West Virginia's law, and if there were in other contexts, the question would remain whether or not the state could make out the showing that this is being treated in such a substantially different way than other forms of medical care. I do think that judges are equipped to make those determinations as they do in many other contexts.
A lot of categorical statements have been made this morning in argument and in the briefs about medical questions that seem to me to be hotly disputed. And that's a bit distressing. One of them has to do with the risk of suicide. Do you maintain that
Let's go there.
the procedures and medications in question reduce the risk of suicide?
I do, Justice Alito, maintain that the medications in question reduce the risk of depression, anxiety, and suicidality, which are all indicators of potential suicide.
And do you think that's clearly established? Do you think there's reason for disagreement about that?
I do think it is clearly established in the science and in the record. I think, as with all underlying questions of looking at evidence, there can be disagreement. I don't dispute that. But here, and going back to questions about the Cass review, for example, the Cass review only looked at studies up until 2022.
I don't regard the Cass review as necessarily as the Bible or as something that's true in every respect. But on page 195 of the Cass report, it says, there is no evidence that gender affirmative treatments reduce suicide.
What I think that is referring to is there is no evidence in the studies that this treatment reduces completed suicide. And the reason for that is completed suicide, thankfully and admittedly, is rare, and we're talking about a very small population of individuals with studies that don't necessarily have completed suicides within them. However, there are multiple studies, long-term longitudinal studies, that do show that there is a reduction in suicidality, which I think is a positive outcome to this treatment.
Pretty sure there's a bunch of other
question about another issue that came
studies
up
that go the other direction.
Justice Kagan's questioning and Justice Barrett's questioning in particular, and that is whether transgender status should be regarded as a quasi-suspect classification. And Justice Barrett,
which is where they want to go ultimately.
That's
the end game.
have mentioned in explaining when something should be classified as a quasi-suspect classification, and that is a history of discrimination. Another one is immutability. Is transgender status immutable?
May I answer, Mr. Chief Justice?
Sure.
So I would say that under this court's consideration of that criteria, it is a distinguishing characteristic. Transgender people are characterized by having a gender identity that differs from their birth sex. That is distinguishing and discrete. And that also, within the characterization, I would also point, if I could, to the history of discrimination, and there are many examples of in-law discrimination, exclusions from the military, criminal bans on cross-dressing, and others.
Thank you, counsel. I think I lost track of the discussion you were having about, what was the point you were trying to make?
I think,
or somebody was trying to make.
Yes, I think it was me. And the point about COVID and the question of whether or not this court has ever considered applying heightened scrutiny to contexts in which states are grappling with evolving medical evidence. And I would point to Justice Gorsuch's statement in South Bay United Pentecostal, in which the purpose of heightened scrutiny, even when the government is grappling with experts of a medical character, is to still test whether or not that infringement on an individual right or that use of a suspect classification meets the heightened scrutiny standard. It is not exempt simply because it is in the context of public health or medicine.
I don't want to relive the COVID cases,
You and me both.
But it does seem to me that one of the issues that came up, and as to which courts around the country had vastly different views, was the lack of knowledge about precisely what was going on, what the effects were going to be, what the remedies were going to be. And if this is similar to that, I think that would be very troubling to say that in such a evolving situation, we are going to decide what the right approaches
Right,
are.
the
I mean,
courts
you
are not
said
appropriate.
at some point that
The legislature is the body that can
Tennessee
decide
court,
that.
or not the Tennessee court. This court
that's responsible.
is just as qualified as Tennessee to make the decisions here. And it's not really so much a question of qualifications. It's more questions of constitutional allegation of authority. And we might think that we can do just as good a job with respect to the evidence here as Tennessee or anybody else. But my understanding is that the Constitution leaves that question to the people's representatives rather than to 9 people.
9 judges, that's right.
None of whom is a doctor.
Good job, Justice Roberts,
and
good.
Particularly and maybe I'm just repeating myself, but you can look, should we follow the United Kingdom position from 3 years ago? Should we follow the United Kingdom's position now? It seems to me that it is something where we are extraordinarily bereft of expertise.
Yes.
Well,
Anyways, what you think?
Mr. Chief Justice, if I could first respond to the first half of your question about whether or not this is comparable in terms of the underlying science with respect to COVID-19, and I think absolutely it is not. I merely use that example to say that the court has not hesitated to suggest that heightened scrutiny applies in contexts that deal with medicine and science. And then with respect to what is the role of the courts, I continue to think it is to test whether or not a law is properly tailored, and that is what the district court did here. And in fact, the underlying science and the evidence showed that Tennessee's assertion of harm and their prevalence were not supported. The district court made factual findings to that effect, of which Tennessee has not argued were clearly erroneous. And so if what is left here is just bare rationality review, Tennessee is in essence saying, let's not look at the evidence at all. This is a law that bans this medical treatment for minors or for adults, that in all other contexts, what Tennessee does is recognize that there are risks and there are benefits. And usually the state regulates by informing patients of the risks and tailoring to minimize them. Here, what they've done is impose a blunderbuss ban, overriding the very careful judgment of parents who love and care for their children and the doctors who have
Yeah, but they're
recommended the
identifying
treatment.
and articulating a
Justice
harm
Thomas?
against that population.
The point I was getting at
Hey, it's
with
Clarence!
respect to remedies is normally in,
all right,
in
well, I was
equal
gonna wrap it up,
protection
but it's
cases,
Clarence, so we
there's
gotta
a
stick with it.
difference between one group and another. In Bourne, it would be that the women could buy alcohol, but the the male students could not. And what would that be in this case?
So 2 points, Your Honor. I think that what the birth males can do that birth females cannot do is receive medical treatment to live and identify as boys. And what birth females can do that birth males can't do is receive medical treatment to live and identify as girls. That's
Okay,
a
let's
level.
change. What if, would you make the same argument if
I need
we
a
were
whiteboard to
only
diagram this
talking
out.
about puberty blockers?
If it was puberty blockers, I would point to John Doe, who is receiving puberty blockers. The purpose of receiving puberty blockers for John Doe is so that in the future he can undergo a typical male puberty.
No, I'm talking about from an equal protection standpoint, the difference in treatment. Normally in these cases, one group receives something that the other group does not. And I'm trying to discern that in this case.
And so what I would say to Justice Thomas is that a birth sex male can receive puberty blockers to undergo a typical male puberty, and a birth sex female cannot. And if I could slow it down and just explain a little bit how that works. If you're someone who was born male and you are going through puberty too early, you want to be able to have a final adult height that is typical of boys. You may receive puberty blockers so that you can develop as a typical boy.
We all want to be a little bit taller,
Someone
all
who
right?
has a sex of female at birth is also receiving puberty blockers so that they can undergo a puberty like other boys. And so it is the same purpose. And what makes the treatment prohibited for the birth sex female is their sex.
Justice Alito?
Counsel, I don't think you had a chance to finish answering my
Clarence
question
Thomas is
whether
like, what the
transgender
heck?
status is immutable. You cited a bunch of other criteria, but is it immutable?
I think that the record shows that the discordance between a person's birth sex and gender identity has a strong biological basis and would satisfy an immutability test. And I also think under this court's precedence for determining whether something is a suspect or quasi-suspect classification, a distinguishing characteristic is sufficient.
Does transgender status apply to individuals who are gender fluid?
Oh,
I
good
think
question.
that the distinguishing characteristic is to have a birth sex that does not align with, or a gender that does not align with one's birth sex. It may include people who have
Chase got confused there.
different understandings of their gender identity, but I think it is still the distinguishing
It's dynamic,
characteristic
man.
of a birth sex and a gender identity
changes.
that are incongruent.
Are there individuals who are born male, assigned male at birth, who at one point identify as female, but then later come to identify as male, and likewise for individuals who are assigned
Is there
female
a
at birth,
reversion?
at some point identify as female, identify as male, but later come to identify as female? Are there not such people?
There are such people. I agree with that, Justice.
So it's not an immutable characteristic, is it?
I think people's understanding of it shifts, but the evidence shows that there is at least a strong underlying basis. And I think the normative reason for that particular consideration is whether or not this is something that someone should or could change, and whether they should have to change it in order to receive constitutional protections. And I think transgender status squarely fits within that.
We have said that having a disability is not a suspect or quasi-suspect classification. So if we were to agree with you on the question of quasi-suspect classification, how could we justify saying, for example, that a person who is schizophrenic
or lost
does
a
not
leg
fall within a category that is not a law
Justice Alito.
that distinguishes
maybe they're
around
like schizophrenics,
a suspect
you know?
classification.
They think
I'm
they're
not
multiple
suggesting,
people.
Gender dysphoria is a disease.
I would love to see the
I'm not
face of this
suggesting
Chase
that at
person
all.
here.
I'm just saying, how could we justify
court
that
right
different
now.
treatment?
I think that
It's immutable in the sense that there isn't any cure for it. There's been severe discrimination against people suffering from schizophrenia. At one point, they were locked up in hellish institutions. They can make a valuable contribution to society. Think of John Nash. How would we distinguish that?
Justice Alito, what I think would be the difference is that in Cleburne, the court in essence said as to the distinguishing characteristic that this was a large and diffuse group of individuals who have different forms of disabilities, and that group of people had been able to secure some protection through the legislative process. But again, if this court certainly does not have to reach the question of transgender status as a quasi-suspect classification, SB 1 on its face hinges its prohibition on inconsistency.
I understand that, but would you dispute the proposition that transgender status is a very broad category? Doesn't the American Psychological Society Association say it's an umbrella term?
I don't know exactly what the American Psychological Association says, but I don't dispute that there are people who fall within a transgender identity who may not fit into a binary identity. I still think that the distinguishing characteristic applies to every single transgender person, which is a birth sex that is inconsistent with their gender identity. And of course, here on SB 1, this is a law that I think is easiest to understand and the most straightforward classification on the basis of sex.
When asked whether you differed from the SG's position, I assume that if you win in this proceeding, what you're asking for us to reverse is the Sixth Circuit conclusion that rational basis review applied. I think, as does the other side, that each of you should win on that question. But are you differing from the SG? That should be remanded to the court below to apply strict intermediate scrutiny in the first instance?
No, Justice Sotomayor, we're not disagreeing.
Now, with respect to Justice Thomas's question, I'm not sure you answered it. You did in part, and you said
no one knows
the
really
relief
what she
you're
said.
seeking in the lawsuit, assuming you win on the intermediate standard review, is to permit your plaintiffs to receive the medication other children receive. I don't know if he was suggesting that one of the things we can go up in discrimination or we can go down, which is, but I don't think we've even decided who makes that choice, because the other alternative is to block the usage of all of these drugs for all children, which would present a very different than Arlington Heights, perhaps, question. But the point is that what the relief is still something that has to be determined as well.
So if I could clarify, Justice Sotomayor, I don't think that the relief we're seeking is for our clients to receive the medication. The relief we're seeking is for SB 1 to stop being a barrier to their ability to continue to access medical care and make the individualized assessments
so they want to
with their
invalidate the
doctors.
law.
So it is just simply an injunction of the barrier to the medication that they had been receiving in Tennessee.
Which would invalidate the law. Yeah.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh?
Two basic questions. So whether we apply a rational basis or intermediate scrutiny, either way, you end up looking at the state's justification, and they are articulating a health and safety justification. So it's not simply morals legislation, as they've described it. It's health and safety justification. And it seems that there are risks and benefits both ways here. So it's very hard to weigh those, at least as the briefing has set out the issues. If the treatment's barred, some kids will suffer because they can't access the treatment. If the treatment is allowed, these treatments are allowed, some kids will suffer who get the treatment and later wish they hadn't, and want to detransition. At least
Right.
that's how
It's a public debate.
see the
Yeah.
positions set out in the briefs. And so there are risks both ways in
And the people voted.
here, allowing the treatment
Legislature
or
acted.
not allowing the treatment. And how to choose there is a very difficult judgment call, it seems to me, but it's a difficult judgment call as a matter of policy. And then for us to come in, and this is repeating what I said earlier, but I want your reaction to it, for us to come in and to choose one side of that, knowing that either way, people are going to be harmed. There's no perfect way out, at least as I've read the briefs here, where everyone benefits and no one is harmed.
Chase says just
Right,
trust the science.
The difficulty
Their
of the
science is
issue
right.
is some people are going to be harmed.
Well-
And then the question becomes, how does the court choose which group? Why isn't that a choice for policymakers as best they can
Yeah.
to make that choice in the first instance? So
Like
I
the
just throw that out there
legislature,
and
yeah.
take your reactions and anything you want to say on that.
Okay, so if I could just make a few points in
Okay, I
reaction.
had one more point, sorry,
Okay.
to add to that. And I don't think, with respect, what you and the Solicitor General said, oh, we'll just send it back to the district court and they'll make fact findings. It'll be back here in a year and we're going to have this same discussion as I see it. So just to get you thinking about that too. Go ahead, have at it.
So a few points, Justice Kavanaugh. And the first is I don't see this as the court choosing what is the appropriate response here. What I see the role of the court is assessing whether the choice that Tennessee made is one that they can justify under heightened scrutiny. And so that question is whether or not by taking this decision away from the adolescents, their parents, and their doctors based on claims of harm, that protects children and protects children from adverse side effects. And what I think the record here shows, and again, this is a preliminary injunction record, what it shows is broad categorical ban but does not advance that interest. That doesn't mean that a more tailored response would not advance that interest, in which you may be able to actually come out with a solution to ensure that you are protecting those who may come to regret this treatment, which are much, much smaller than those who benefit and find it medically necessary, something like West Virginia did. And I think the relevant inquiry here is whether what Tennessee did meets their constitutional burden because they use sex-based classifications to pass this law. And then on two quick other points that with respect to the difference between rational basis and heightened scrutiny, yes, of course it will be weighing the state's asserted interest in both circumstances, but there's a world of difference between rational basis and heightened scrutiny, and we think the Sixth Circuit got it wrong by simply applying rational basis here. And to the question of, is remand a sufficient...
Well, can I just stop you there? If even under rational basis, if there were no benefit to anyone, then it would probably lack a rational basis. So I guess in the end, you still come down to there are risks and benefits both ways, either way you go here. And I don't know whether rational basis or intermediate scrutiny, however that gets applied, you still have to look, is there a real justification here? I think you look at that either way.
And I think the difference under heightened scrutiny, there's a chance to look at the evidence in a much more substantial way and have the state come forth and show whether they've met their burden. In terms of your question, Justice Kavanaugh, about is it sufficient to just remand it, it will be back up here again, I would say two things in response. I think that there are often examples where there's a threshold question and it goes back down on the application of heightened scrutiny. And I do think an instructive case is Johnson versus California here, in part because it gives us some guidance for what happens on remand in the application of scrutiny.
From
and that,
Nightwatch.
of course, was when the court was considering whether or not to apply strict scrutiny to racial classifications in prison or Turner deference. And when the court reversed and said the wrong standard was applied, strict scrutiny still applies, and sent it back down, it did so with guidance that even under strict scrutiny, the lower courts could take into account the particular context of prison. And I think here, this court could send it back down with instructions to take into account the particular context.
And just one point there, you agree that there's some group of people who receive the treatments who later wish they hadn't and wish to detransition. I know you say it's a smaller group. I understand that. I just want to make sure you agree as a factual matter there is some
Chief Justice Roberts also
I
brought
agree as
that
a factual matter, as there is in all areas of medicine.
And then on the sports question, I want to get your reaction as well, which is it logically and legally possible to apply intermediate scrutiny and say that the Tennessee law and the other laws like it do not satisfy intermediate scrutiny, but laws that limit women's and girls' sports to exclude transgender athletes would be constitutionally permissible? Is that legally and logically possible?
How are you reconciling?
I agree with the Solicitor General that it's legally and logically possible because in the application of heightened scrutiny, it's wholly different state interests that are being asserted.
Because it's medical care versus
Justice
sports.
Barrett?
Mr. Trengale, I wanted to give you a chance to see if, I'm not sure if you named all of the laws when we were talking about de jure discrimination before. You mentioned bans on cross-dressing and bans on military service. And I had thought of the military service, but I didn't know about the statutes prohibiting cross-dressing. Could you think of others? Are there?
I would say that there are other examples that exist in which sometimes homosexuality and transgender status are lumped together in discriminatory frameworks as language has changed. But I think the most salient to me would be the cross-dressing bans and the explicit bans on military service for transgender individuals.
Okay, and thinking about when we identify suspect classes, the factors that we've considered, one of the ones that the Sixth Circuit addressed was political power. Do you have a reaction to the Sixth Circuit's discussion of that?
I would just say, Justice Barrett, that I think looking out at the country at the moment, that there is a significant challenge for transgender people to protect themselves in the political process where you do have laws excluding transgender people from places where they need to go in all aspects of life, and there is a difficulty in that type of majoritarian protection. I think that's precisely what the political powerlessness prong of the test accounts for.
Thank you.
Like you need
Justice
the courts
Jackson?
to come in and step in there.
So I guess I'm suddenly quite worried.
I think we're about good on this one. So Amy Coney Barrett wrapping it up. Ketanji Brown Jackson. We'll see what the court says. We think we know how the liberals will go, but what we saw today was, I think, some skepticism from Amy Coney Barrett and some skepticism from Chief Justice Roberts. Judge Alito was not mincing words here at all, so we know where he's going to be voting on this thing. I think that Clarence Thomas will be there as well. Kavanaugh sounds like he's skeptical about it. So depending on how Amy Coney Barrett goes, we might have a 5-4, maybe a 6-3 decision, but that's in the Supreme Court. And that's obviously going to be a big case when that comes down the pike because it is the cause du jour of the left in America today for whatever reason. We'll see how much energy is behind it now that they've lost the election. And now some people are pointing to their more extreme positions on these issues is one of the reasons they may have lost. But we'll see where this goes once the Supreme Court issues their opinion. All right.